Cancellation of removal for non-lawful permanent resident. In this video, I'll talk about cancellation of removal. I will talk about the 10 years physical presence, continuous physical presence for 10 years. I'll talk about when does the clock stops, okay? Bijoux Ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing. And please don't forget to hit the notification bell so you don't miss any of my videos. If you enjoy the content, go ahead and like, share, and don't forget to comment below. I'll get to those comments as I always do. Anyway, let's get right into it. Cancellation of removal. We have talked about cancellation of removal before. If you want to have a background of what cancellation of removal is, if you qualify, just go ahead and refer back to my previous videos. But in this particular video, what we're going to do is we're going to explain first of all how the clock works. How do you calculate the 10 years? Because one of the requirements when it comes to cancellation of removal, it says that you must have been in the U.S. continuously, lived in the U.S. continuously for a period of 10 years. That's one of the requirements. But how do you know? How do you calculate that? And then we're going to explain the latest U.S. Supreme Court decision on cancellation of removal and the clock stop. When does the clock stops? Okay, let's start with the latest U.S. Supreme Court decision. This decision, as you pretty much most of the people are aware of it, the decision came on April 29, 2021. Okay, the U.S. Supreme Court ruled in Chavez v. Garland that a charging document, which we call the Notice to Appear, NTA, must have the date, the time, place of the court hearing in order to stop time from accruing for cancellation of removal. So, having said that, let's now explain how does the clock works. Or maybe let's just say, when does the clock stops? When does the clock stops? The moment you receive a notice to appear, if you are in removal proceedings, that's when the clock stops. You cannot afterwards go ahead and calculate all those other years in order to come up with that 10 years requirement. So, for example, let's say you have been in the U.S. Since 2015, okay, and you received the notice of appear in 2020, that will be 5 years only. So the moment you receive that notice to appear, it is 5 years and the clock has stopped. Let's say after that you receive that notice to appear in 2020, your court doesn't, you don't get to court until maybe 2025 or 2023, you are not going to count those years because you have already been advised in the notice of appear with the charges, and you will not add those years. But what happened in this case, the case that went all the way to Supreme Court, what happened is the person in the case was arguing. The person was arguing that, of course, they received a notice to appear, but the notice did not have the time, the place, or the date of the hearing. So they couldn't consider that notice as if they have received notice. That's why the court has to count all those years after they have received that defective notice in order to come up with that 10 years. And the case went all the way to the Supreme Court, and finally the Supreme Court has given us clarity. So if you have a case, okay, and you receive a notice to appear that is defective, what you have to do is let us know so we can do a case assessment and really to know whether you are qualified to this type of relief under cancellation of removal. If the notice to appear does not have the date, The time and the place of the court hearing, it simply means that your clock has not stopped. So you can, in fact, continue to count your years and come up with that 10 years requirement, really. So in short terms, I'm going to give another example. For example, we're just going to go with a name, okay? Lucy came to the United States in 2017. And then in 2021, she received a notice to appear. She found herself, for some reasons, in removal proceedings, okay? And then she receives a notice to appear. And then when she looked at the notice to appear, remember, she came in the U.S., when did we say she came in the U.S.? In 2017, right? And then in 2021, she receives a notice to appear. That's how many years? 4 years later. And then when she looks at the notice to appear, it looks like the notice to appear is not defective. Unfortunately, in 2021, it's only 4 years. That person hasn't really come up with the 10 years requirement. So Lucy cannot apply for cancellation of removal. But let's say, for example, Lucy gets to the United States in let's give a good example, in 2012, okay? And then in 2020, that's 8 years later, she receives a notice to appear. And after looking at the notice to appear, there's no date, there's no place of the court. Or let's say she received 2 notices to appear, one with the date, one did not have the date, stuff like that. So the one that she received after will not counter for the defective one she received before. So if Lucy has a court hearing in 2022, then she can apply for cancellation of removal because the clock did not stop for her, because the notice to appear that she received was defective. So in other words, if your notice to appear is defective, meaning that it has no date, no time and place of the court hearing, the clock will not stop. So if the notice to appear, let's say, was back in 2011, and then now it's 2011, 10 years later, that notice of appeal was still defective. So 10 years later, you can in fact apply for cancellation of removal. So the way it works is simply that the 10 years of continuous presence is counted before the notice to appear. The moment you receive a notice to appear, you can no longer add the years to your petition in order to claim cancellation of removal. You only go with the previous year prior to you obtaining a notice to appear. Really as simple as that. So the moment you receive the notice to appear, the clock stops. The moment you receive the notice to appear, the clock stops. If you haven't been here for 10 years at that time, then unfortunately you cannot apply for cancellation of removal. But let's say that you receive a notice to appear and the notice was defective, and then by the time you go to court, it's already like 10 years. Now you can apply for that cancellation of removal. Another thing that I wanted to add, is that continuous physical presence also ends when the immigrant commits certain offenses. Certain offenses, when you commit them, unfortunately, the continuous physical presence ends there, like this, the clock stops. You cannot accrue no more time to claim that you have been here for 10 years, okay? Absences, another thing is the effect of absences on continuous physical presence. If you left the country for 90 days, it's not gonna stop the clock. But as long as you, it's no more than 180 days. So basically 6 months, right? If it's no longer than 6 months, then it's not going to count in terms of stopping the clock. So basically, notice to appear will stop the clock. Immigrants leaving the country for longer than 6 months will stop the clock. And then basically criminal offenses that is committed in between will stop the clock as well. So pretty much that's it. That's what I wanted to talk about today, because cancellation of removal is really a difficult type of relief, because the standard is very high. Unusual and exceptional circumstances in order for you to be granted cancellation of removal. And if you add to it the component of time, sometimes it becomes almost like impossible to get there. But we have this decision which allows some people to go back and review their cases and look at their notices and see whether their notices were defective. At that point, they can reopen their case and claim cancellation of removal. I think I have made myself very clear on this one. Criminal bars, what will prevent somebody to actually receive that cancellation of removal relief is a crime involving moral turpitude, offenses relating to controlled substances, that's drug, 2 or more offenses that brought a total sentence imposed of 5 years or more, engaging in a business of being a prostitute, aggravated felony, high-speed flight from immigration checkpoint, firearm offenses, crime involving domestic violence or stalking, really crime of child abuse, neglect or abandonment, or violation of certain portion of domestic violence protection order, espionage, treason, sedition, failure to register or document fraud under the listed of federal acts, false claim to U.S. citizenship, failure to register as a sex offender under the federal law, entry or departure permit fraud, importation of immigrants for immoral purposes, or threats against the president and military expeditions against friendly nations. So basically, cancellation of removal is a form of relief that is granted in some instances. Let's say, for example, you've been here for 10 years and there's no other alternative in order for them to grant you want to stay. You can look if you qualify for cancellation of removal and then apply for it. But it is really a most difficult relief to really be granted, because they have to look at unusual and exceptional circumstances, and not to mention the 10 years continuous physical presence in the United States has to be put into consideration as well. So this is it for today. If you need a consultation or a case assessment, again, 202-751-2180. Email on display. Consultation fees apply. I charge $175. Okay. Bijoux Ngwanda here, immigration lawyer in the DC metropolitan area. This was U.S. Immigration. Until next time, bye-bye.